I am Rebecca Gwilt, co-founder and partner at Nixon Gwilt Law, where we help digital health and healthcare technology companies navigate corporate, commercial, regulatory, and reimbursement law and policy to build great businesses. I am joined by my colleagues Reema Taneja and Sam Pinson. Possibly little known fact, Reema actually teaches a course at American University School of Law on AI law. I'm excited to have her with us today, especially. And we are, all three of us, excited to kick off what will be at least a 4-part series aimed at helping digital health companies make sense of the AI law and policy landscape. It's moving really fast, so it's possible some things that I prepared for this presentation last week are already out of date. I'm sure someone will let me know. But our team here will be sharing as much as we can on LinkedIn, on the firm's Innovation Insights blog, via our monthly newsletter as things develop over the next year and a couple of years. So go ahead and follow us, sign up if you haven't already. Before we move on, I will be happy to answer the icebreaker. My choice is SpongeBob for the cartoon character that I would most like to invite to breakfast. He is super optimistic, forgives easy, very grateful, and he cooks burgers. Also, please feel free to ask questions in the Q&A. We're not going to be able to get to all of them during the presentation today, possibly, but we promise to answer any of them that you submit either during or after. We've just got a lot to cover today. Quick disclaimer, today's video is for informational purposes and should not be considered legal advice. We are lawyers, but we may not be your lawyer. Let's start off with what we're covering today. So we are going to talk about 3 primary things today. 1, how the federal government and the states are regulating AI tools and functions in digital health today. 2, key areas of risk for digital health companies so that they can, practical areas of risk they can audit and examine to de-risk their AI tools and services. And 3, fundamental principles for AI deployment to help you prepare for compliance and the impending regulatory changes in 2024 and 2025. Our goal, and hold us accountable to it, is to make sure to bring you actionable guidance you can begin to use right now. We're going to start off with the first poll, just to find out sort of who is in the room today. I'm loving seeing the answers come in on the chat as well. I'm going to try not to get distracted. Timon is a really good one. I know every single word from The Lion King. So who do you identify as in the universe of AI and healthcare? We'll just continue on going while you guys answer that poll. We're going to start with a big picture view of AI funding and use cases to ground us in our discussion about what we mean by AI-powered digital health solutions and why is that such a hot topic right now. HIMSS is going on as we speak. We just got back from the HIMSS AI pre-conference forum. It's all that anybody is reporting about right now. As many of you know, healthcare innovators have been using AI in their products for about half a century, since Alan Turing. It has become exponentially more powerful, but it's not new. So Sam, tell us what the big deal is.
Yeah, so while you all take the poll, we've assumed for the purpose of this presentation that the audience knows kind of the general definition of AI, but as we move forward into 2024, we know that AI is more than just kind of your traditional AI use cases, and that generative AI is kind of the hottest word on the street right now when it comes to artificial intelligence. And to Rebecca's point, we attended an AI and healthcare conference, and it got to the point where panelists were basically saying that you could swap out the use of AI for any type of technology, which really just, emphasizes the pervasive use of AI today. So when we look at this chart, there's 3 kind of main takeaways that I want the audience to keep in mind here. The first is sort of the breadth of the AI subsectors. It's not just, application and models. When we talk about AI, we consider everything from data management to infrastructure that enables AI, to machine learning operations. The second is just the massive growth that we've seen in funding over the last few years. This chart goes to the 3rd quarter of 2023, and what we see is that funding in 2020 came out to around $2 billion, and the invested capital has grown to over $20 billion through 2023. So we're talking about a 10x increase in a short amount of time. And then the last thing that I want the audience to pay attention to here is that we've seen a paradigm shift from just sort of your general use AI applications to a focus on models. And when we talk about models, and specifically foundation models, we're talking about ChatGPT, Gemini from Google, so kind of your mainstream models at this point. We can go to the next slide. So in addition to the diversity within the AI sector, that theme definitely carries itself well into the healthcare industry when we talk about use cases of AI. We can look at clinical uses, non-clinical uses, and then also the difference between consumer-facing and professional-facing AI use cases. There are some emerging applications of AI that go into areas like patient triage and care coordination, and then some more standard uses for areas like scheduling, billing, and claims processing. Another takeaway from the conference we attended was that sort of your administrative non-clinical use cases are picking up a lot more momentum than the clinical use cases, and health systems are more risk averse in their applications of AI. And when we look at some of these areas, you can see that because there are such a wide variety of clinical and non-clinical use cases, what we'll see throughout the presentation is that there are a wide variety of principles, regulations, and best practices that apply because of the diversity of applications of AI in healthcare. And it looks like.
All right, let's see the results of that poll quickly. Can you help us out, Reema?
Yes. So I just ended the poll. I'm going to share the results.
Okay.
Can everyone see those?
Okay, exciting. Okay, so lots of folks here who are building digital health tools. That's super exciting. That's almost half of you. So again, we're going to be giving you very practical solutions around this, or at least practical areas to look into. Some of you are purchasing AI-powered solutions. We can talk to you about that as well. The same principles are going to apply. We'll talk about that when we talk about governance. Some technologists here, investors here, and lots of folks sort of just learning, which I think is absolutely a place where all of us still are, including your humble speakers. So this is super helpful. I think there'll be a lot for each of you to take away here. And don't forget to put your questions in the Q&A box. Our chat is closed now. Thank you for your submissions. So we're going to go next to an actual photo of me for the past couple of months, reading all of the AI policies, legislation, guidance documents, news articles, etc. It's been a wild ride. I'm glad to be here on the other side of it. Just kidding, we're still in it. There's a lot to cover here. So we're going to start off with the fact that if you've been attempting to get your arms around this topic, you're already aware the legal landscape is in its infancy, but growing rapidly. Without a centralized enforcement framework, it can be really confusing and frustrating, which is sort of what we're hearing from our clients. And while the regulators haven't finalized their plans, the industry is beginning to impose its own standards, which is impacting how AI is being commercialized in the market. My goal today, again, is to bring you up to speed on where things are, where we think things are headed, and what you can be doing to prepare for what's coming. This is the first in a series of webinars we'll be hosting this year, and you can absolutely bet that there will be new developments between each. So we're gonna call this our foundational presentation and be thinking about the kinds of things that you would like for us to talk about later. We're going to have that in the poll to inform our next webinars in the series. So let's touch briefly on the history of what I call apples. These are AI policy and laws. I said that too many times during the planning of this, so now they're apples. I've included only those apples I consider to be healthcare related. Obviously, there are other initiatives going on in the AI world involving national security and housing and lots of other areas of the economy. The big takeaways from this slide, and I'm not going to go into each one of these, you're welcome, is that starting around late 2022 and early 2023, the government put its efforts into hyperdrive. May or may not have been related to the ChatGPT release in November 2022, maybe a coincidence, but they started putting out a lot more guidance. They started having a lot more discussions in Congress, in the Office of Science and Technology Policy, which is in the Executive Office of the President. There is no harmonized framework right now, but there is growing consensus around core principles for companies who are developing and deploying AI-powered solutions. We're going to cover those principles today. Some of this guidance is meant to apply broadly to any application, and some of it is very product dependent. So for example, the FDA has guidance out that applies generally or particularly to AI software as a medical device. The ONC, which is the only HHS agency that has regulated on this so far, put out a rule that's called HTI-1 that is specific to certified electronic health records technologies and folks that are sort of integrating with them. So some is general, some is specific. And you may be aware that the industry itself is fighting for a seat at the table. Can you go to the next slide? So here's a small sampling of what the industry is doing right now. They're all tackling a set of principles and frameworks and standards for the responsible adoption and assurance of artificial intelligence in healthcare. The Consumer Technology Association has put together some standard definitions. There is no standard definition. Everybody's fighting for their definition to be the standard definition. AMA has released AI principles. The American Telemedicine Association has released AI principles. The Coalition for Health AI has released AI principles. The National Academy of Medicine is developing currently a healthcare AI code of conduct. And you may have heard on Monday, while Sam and I were at the AI forum at HIMSS in Orlando, they announced another group, which is sort of driven by Microsoft and more than a dozen of the country's largest health systems, called Trustworthy and Responsible AI Network, or TRAIN. Healthcare loves its acronyms. Unlike CHAI, which is the Coalition for Health AI, which is also developing a set of definitions and collecting stakeholders, et cetera. Some of the members of TRAIN and CHAI are the same. TRAIN doesn't include any of the big tech competitors, so it's really Microsoft, and it also doesn't have representatives from the federal government, which is what CHAI has done. So I don't know the inside politics of this thoroughly. They have members who are members of both, probably betting on, people who are big enough betting on two horses, thinking one of them will win out. But they are both putting together sets of principles to help stakeholders implement, which is just making the whole landscape a little bit more muddy. At the same time, you shouldn't be surprised to hear that California and New York are leading the states in the development of their own comprehensive AI legislation and policy. So like many other healthcare laws, we're likely to eventually have a patchwork of state and federal regulations by which healthcare companies will need to abide. It's unlikely, in my opinion, that clarity is going to arrive anytime soon. But what we do know is that some common themes and frameworks are driving much of the policy here in the United States at both the federal and the state level, as well as internationally. And those are the frameworks and principles we're going to focus on today. The EU AI Act, in case any of you are following that as well, which will have international implications, was passed by the EU's Parliament yesterday. So again, all of this is live and happening in real time. All right, so we're going to break down what we believe are the most important principles digital health and healthcare companies need to learn. We've actually gone one step further to help make this actionable, and we're going to share with you at the close of the webinar an even more streamlined set of principles that all companies can use to build their AI governance posture. Again, there's little harmonization among all the different groups putting out these standards and lots of overlapping principles. So our goal today is to show you, we have read everything that's out there. Our goal today is take what we have read and, based on our experience guiding companies through other complex regulatory models, share with you what major principles we believe healthcare innovation companies should use to guide the development and deployment of this technology. But again, we're going to start with the primary learnings from the most important principles frameworks. And those are the White House AI Bill of Rights, the NIST RMF, the Biden Executive Order on AI, and the ONC HT1 regulation. Go ahead, Reema.
All right, so I'll start by talking about the first framework that Rebecca mentioned, the AI Bill of Rights. So this was presented by the White House Office of Science and Technology Policy, and it emphasizes the protection of civil rights and promotion of values in the AI deployment. It's not a binding document, but it is meant to guide how regulators may shape the use, design, and deployment of these systems across the industry. So companies building AI solutions or those who might be purchasing AI solutions should understand that the federal government's primary concern in terms of AI in healthcare is the safety and health of American citizens. As you might have seen in the chatter in the industry, a lot of the federal government officials are really paying attention to how AI is being used in terms of taking in patient data, if they're being transparent, et cetera. So they are really looking to developers and deployers to make sure they're protecting Americans who are using these tools. So a creator, seller, or buyer of these tools, if you start with these policies and these principles, you can't go wrong.
Okay, so first, who is NIST? Any privacy and security folks in the room might know, but I'm sure that other folks are scratching their heads. They're part of the U.S. Department of Commerce, and their mission is to promote U.S. innovation and industrial competitiveness. So they're a standards and technologies body. The NIST RMF risk management framework provides a comprehensive framework companies can use to manage risks associated with the deployment and use of artificial intelligence systems. The guidance outlines a structured approach for organizations to ensure the development of trustworthy and responsible AI and technologies. Those are words you're going to hear often: responsible AI, trustworthy AI. And these emphasize governance, risk assessment, and ethical considerations, very much in line with the White House Bill of Rights. This framework is already being deployed across the ecosystem, as Sam and I have learned, and is forming the basis of development of industry standards as well as FDA policy regarding sort of ongoing lifecycle management and continuous improvement for AI solutions. Any of you that are building software as a medical device, Nixon Gwilt was at the Vive conference last week or 2 weeks ago, maybe. Time is blending together, but we heard the head of the CDRH, Troy Tasbaz, talk about how they're using the RMF framework to build the new system for the FDA to monitor in a sort of post-market sense that technology. The risk management framework consists of 4 primary components. These components are to govern, which focuses on establishing leadership commitment and governance structures for ethical AI development. Map, which involves identifying and understanding AI system risks and their impact on stakeholders. Measure, which requires assessing the performance of AI systems against defined metrics to ensure they're safe, secure, and trustworthy. And manage, which involves implementing controls and processes to mitigate identified risks and to monitor system performance continuously. Next slide.
All right, so this is an executive order that outlines the government's commitment to leading the safe and responsible development of AI technologies. It's directed towards federal agencies to develop standards, regulations, task force, et cetera. So as you've been seeing, there are a lot of different agencies who are coming out with frameworks and principles to help guide the industry. So this EO kind of includes the primary principles that they should be focusing on. It also calls upon agencies to look into how AI may trigger enforcement under current law. So right now, a lot of regulators are trying to figure out what existing law might apply to AI currently. So it calls upon the agencies to look into that a little bit more specifically. It highlights 8 guiding principles, 5 of which are directly applicable to the healthcare sector. One key point is that the government needs to focus on balancing individual and collective safety with the need of innovation to remain competitive globally. So this is something we've seen in healthcare innovation across the board and in digital health in general. So that principle lies true here as well. Of note, the EO also stresses that the federal government will promote a fair, open, and competitive ecosystem and marketplace for AI and related technologies so that smaller developers and entrepreneurs can continue to drive innovation, which is promising to hear that they are considering that angle as well. So this executive order is binding on federal agencies, but not binding on the industry. But it does reveal the key principles that agencies will use to guide the development of guidance and regulation regarding the use of AI.
Yeah, so as we move through our principles-based conversation, we kind of finish with the ONC FAVES principles, which stands for fair, appropriate, valid, effective, and safe. And to Rebecca's point, these principles are part of the HTI-1 final rule, which goes into effect later this year, and it's applicable to certified health IT, HRs. But systems and other buyers want to see governance programs that reflect these principles, to reflect an appropriate risk management strategy and also for sell-through. So the key point with ONC Faves is that it's a great frame of reference for developers and deployers of AI. But at the same time, this is a more technical take written by ONC, which is the Office of the National Coordinator for Health IT. ONC's goal is to develop a nationwide standards-based health information exchange to improve healthcare throughout the US. So ONC regulates standards for EHRs and data sharing in healthcare. So you can see why, ONC's principles-based approach is one that we definitely need to pay attention to from a development and deployment perspective. In addition, the HTI-1 rule from which Faves was born imposes certain requirements for predictive decision support and evidence-based support interventions. So you can see why when you get into interventional applications of AI, you need to ensure that the models are fair, prohibiting bias, they're appropriate, they're used for the proper clinical application, they're valid. They've been shown that, the values accurately reflect the internal and external data on which models were trained. They're effective. So we want algorithms and models to have a real world benefit. And lastly, and arguably most importantly, they're safe. We ought to have algorithms and models deployed in the clinical context that are free from unacceptable risks. So as we transition into the next session of the webinar on risks specific to digital health used in AI, we're going to see what the audience thinks and put up another poll.
Yeah, and while you're answering this poll, I just want to zoom out a little bit because, 4 frameworks that contain 19 different sort of parameters sounds like it's a lot. It really is, we're trying to go from the whole ocean to a river, to a pond, to a cup of coffee or tea. And so these 4 frameworks, the way that they interact is, first, we have the AI Bill of Rights, right? The White House said, here's what's most important to us, and it's protecting the American public. And here are the 5 rights that the American public should have as it relates to AI. Then they got real specific. They pulled together stakeholder groups. They built, the administration, along with a number of other agencies and members of the industry and the public, built what would eventually be the executive order that came out. The executive order said, NIST, go make us a risk management framework. And agencies, and the executive order wasn't just for healthcare, but agencies go out and build regulations and use these principles to build these regulations. And based on that mandate, the Office of National Coordinator built the HTI-1 rule. So what the HTI-1 rule tells us is this is one way an agency is translating what the Biden administration put out in their executive order on AI into actual regulatory language. And I think it's really interesting that the ONC strategy was a disclosure strategy, right? It doesn't have a bunch of post-market surveillance. It's not very specific to how AI is built. It is a transparency rule. And so, it remains to be seen how the other agencies, including sort of HHS proper and CMS, regulate on this, but it is the best evidence we have so far of an agency translation of White House policy. All right, so the next question is about sort of identifying the key risks. We wanted to know from you what you're most worried about when it comes to AI, and then we'll tell you what we think you should be thinking about. Reema, do we have enough to close the poll?
Yes, closing it now, and here are the results.
Okay. All right. So one, kudos to the participants, because I was hoping to see more patient safety risk than anything else. I know you were forced to sort of choose one, but it's one of the things that is really core to every framework, every principle that we're going to talk about today. All the rights that came out of the White House Bill of Rights, they really are about protecting people, protecting patients. It looks like none of you are worried about nothing. So yes, we're going to touch on each of these today and sort of what within these categories you might want to think about. For more information about this and how to implement this, certainly you can reach out to us. And again, follow the content we're going to be putting out this year. We're going to try and dig into all of these things. But at a high level, let's start with sort of our big 6 categories of risk that we like to think about. Reema, can you go to the next slide? There we go. So we're going to zoom in and talk about these risks, from a practical perspective. These are regulatory, data protection, and IP. That includes cybersecurity, reputational, contractual, litigation, and governance risk. And let's start with Sam.
Right. So everybody's favorite topic when it comes to AI is how the regulators are going to play into this. So taking each in turn, starting with the FDA. The FDA is looking at how software is being used as a medical device, and the FDA already has some pretty comprehensive guidance out there for clinical decision support softwares and softwares that fall under another category called enforcement discretion. So the FDA, while they haven't put out specific guidance towards LLMs, their latest AI guidance came out actually 2 months before GBT was launched. Some of their existing papers do provide somewhat of a workable framework through which to base a medical device analysis for an AI software. The next one is the FTC. So the FTC exists to protect consumers, and they've put out information through press releases and guidance talking about how developers and deployers of AI need to clearly articulate what services they're providing and how they're using patient data, right? We don't want companies to say one thing and then do another, especially in an area as sensitive as healthcare and patient data. Next, we have HHS, which is the Department for Health and Human Services. We touched on this a little bit earlier with the HTI-1 final rule and the FAVES principles. But the key takeaway from the HHS perspective is that you already have HIPAA. And I think, some members of the audience are probably intimately familiar with HIPAA and how it applies to patient data, but it's worth keeping in mind that HIPAA does not, necessarily change because the application and use of patient data switches to an AI context. The USPTO, of course, comes into play from a trademark and patent perspective. So when you're going through the early phases of registering for intellectual property protection, the USPTO is still going to have some guardrails in place and requirements for AI software development. And then lastly, we have, or second to last, we have the DOJ, Department of Justice, and they put out a subpoena recently for EMR vendors where prosecutors are starting to look into how pharmaceutical and digital health companies are using generative AI technology and their role in facilitating some fraud and abuse concerns and violations. And lastly, and this is probably one of the most dynamic areas of the regulatory conversation, is the state agency and state regulator perspective. So we've seen some developments from states like New York, California. There's been some proposed legislation out of Georgia, and it just goes to paint a broader picture here, which is that right now we really have a fragmented landscape for AI regulation, but hopefully as we move on and these technologies become more commonplace, we can harmonize and have a path forward from a regulatory perspective.
All right, so the next area of risk that we wanted to draw your attention to reflects data protection and intellectual property. So first, when we're talking about input versus output, input refers to the data that's put into the AI tool, and output is what comes out of it when it's used by the deployer or another user. So from a data protection perspective, developers and deployers will need to make sure they have appropriate consents and authorizations in place to input certain data into the tool. Another key point is to think about whether or not you are training the tool on truly de-identified data. That's a common area of concern for those who are building these AI tools. And also making sure that you're implementing safeguards into the platform to ensure that the data is protected appropriately. From an intellectual property perspective, deployers will need to maintain rights in the inputs, and developers from a liability perspective will want to disclaim liability from output. So what that means is usually from a contractual perspective, which Sam will talk about later. You'll want to be clear on who owns the data that's going in, the data that's coming out, and the platform pieces in general. From a liability perspective, something to think about is balancing IP ownership rights with potential liability for having such rights. So if something goes wrong with the AI tool, who's liable for that? Is it the provider, the user, the developer, the deployer? You'll want to make sure that it's clear on who exactly is liable for the tool. And from a data perspective, making sure that you're monitoring how data coming into the tool is being used, and regularly conducting risk management testing and validation of the tool to make sure that the data is protected will be important as well. From a licensing perspective, there's a lot of questions about how the AI tool should be licensed, whether the algorithm can be patented, whether the final product contains IP rights that a developer or deployer can obtain, and also making sure from the output perspective, who can license rights to the data outputs, which also is usually reflected through contracting. From a cybersecurity perspective, there's an ongoing concern to keep these tools and systems safe and secure from cyber attacks and having an overall security structure in place, because there is a lot of data that's coming into these tools. So you'll want to make sure that you have those safeguards in place, perform security risk assessments, engage in regular testing just to make sure that your security is tight. All right, so the next slide talks about risk from a reputational perspective. So these are kind of woven into different principles and frameworks, but what's really important to make sure you're thinking about, especially when you're launching or buying into a new AI tool, is thinking about transparency. So that reflects, again, patient safety and consumer protection. Being transparent with the consumer about how AI is being used in their care is really important. There's also a balance that needs to be in place between disclosing and making sure that you are implementing confidentiality safeguards from a data use perspective. So if you do make public facing disclosures and you want to ensure that your user is clear on how their data is being used, make sure that that's accurate so that the consumer or the patient is not misled. It's also really important to gain consumer trust. So right now there is still some hesitation that the AI tool is being used in patient care might undermine transparency. So building that transparency at the outset will help you gain that consumer trust as well. Bias might be something that you've heard about before. So developers are really trying to make sure that their tools don't contain algorithmic bias. What this means is that sometimes when AI tools are trained on certain data, they're either only focusing on a certain population or a certain patient type. And so those tools end up only being trained on that certain population of data, which can create bias unintentionally. The reputational damage from a discriminatory product or service perspective could be insurmountable. So you'll want to make sure that you are clear on what data went into the training and ensure that it's diverse. Validation, that refers to making sure that you are internally verifying all algorithms that are being used, each piece of the AI tool, making sure that the data you're putting into the tool have high quality. That'll be important as well to make sure that your outputs and the way the tool is being used is appropriate. From a breach perspective, healthcare organizations using these tools should make sure that they have incorporated risk mitigation techniques to prevent data breaches, and also be prepared in case one occurs. Make sure that you have a plan in place on how you're going to handle that breach, and make sure you're clear on which requirements you have to follow from a privacy and security law perspective.
All right, as we move into kind of the key risks that are present and unique to AI contracts, we'll take each of these in turn. The first is you're going to want definitional precision throughout any commercial agreement, whether you're the developer of an AI system or the purchaser of one. You want to make sure that the way you define and describe artificial intelligence and outputs reflect what the program is actually doing, right? So when we have, regulators that haven't come to a firm decision on what AI means and how it should be defined from a private contracting perspective, you should make sure that you pay special attention to the way terms are used in AI contracts. And this is all with the end goal in mind of ensuring that business goals and ambitions are reflected in the legal terms of the agreement. From an indemnification and insurance perspective, given the stakes involved in patient care, these points should be carefully negotiated and evaluated against business goals. There's some emerging literature about whether your insurance policies should reflect AI algorithms above and beyond a traditional cyber policy. So, stay tuned here. As we move to prohibitive terms, what this is referring to is developers that are building their models on top of APIs like the likes of OpenAI's ChatGPT or Anthropic. So you're going to want to pay special attention to the terms of use and privacy policies that you are agreeing to by virtue of building a model on top of these programs. Some of them restrict use cases in sensitive domains. Some place limitations on healthcare specifically. So, given the context and use of AI by a digital health company, you're definitely going to want to look at the terms of use that you're agreeing to as a developer building on these platforms. Next, we go into human oversight, and one of the terms being thrown around right now is human in the loop. And what that's referring to is, given the stakes of these algorithms, we want to make sure that deployers of generative AI applications have some sort of human validating outputs, or that is in the loop per se throughout the use and deployment of the system as an additional risk mitigating factor. As we move into data use, Reema touched on this briefly, but we want to make sure that when you're entering into a commercial agreement with a developer, or if you yourself are the deployer of AI, right, how you are going to use the data that you obtain by virtue of that commercial relationship. And then lastly, we move into privacy and security. So, given the stakes involved with the use of PHI and given the potential outputs from AI models, we want to make sure that consumer data remains private and that systems stay secure. So all of these principles should, one, be carefully negotiated, and two, be tailored to the specific use cases of AI in digital health. As we move to litigation, right? So what happens when there's a dispute between the parties? What happens when something goes wrong with the algorithm? The first here that is seeing a ton of attention right now is discrimination. And what this is getting at, we've seen it in the kind of administrative context already, which is the use of AI to process pre-approvals and claims denials, right? So we've seen some big insurers that have used AI algorithms in part to make coverage determinations, and the jury is still out on how those algorithms were used, whether there was appropriate human in the loop considerations. So there's a huge concern and consideration that needs to be taken into account from a discrimination context. Next, we move into medical malpractice, right? So we want to make sure that depending on the use of the AI algorithm, that we don't have bad or negative patient outcomes.
Yeah, I think for that one in particular, this has always been something that, for years and years that telehealth lawyers have talked about, right? That the technology will somehow introduce malpractice risk. This is really still about clinicians that have a duty of care. And if they are using a technology in a way that fails to meet the standard of care, then the situation, the facts may lend themselves to a medical malpractice action. We have not seen that yet, but it's likely coming.
Yeah, that's absolutely right. And as we move through these, I think the next one that we can take here is breach of contract, right? So two, commercial parties get into a disagreement, whether, it's about payment or how an algorithm was used. Ultimately, these are going to have kind of unique These are going to present unique issues to courts and lawyers working on these cases. So there's going to be potentially, breaches from the use of inputs and data rights, and how you're licensing your outputs, and then also whether or not things like medical advice are being rendered from the use of vendor software. So I think this touches back on the importance of how you draft your contracts in this context to make sure that they're precise and accurately reflecting kind of the business goals of the arrangement.
Yeah, the last thing I'll just say here on breach of fiduciary duty, this is the duty of the head of a company to make responsible decisions about the company. And so this is not just AI related, but this is about responsible deployment of this technology. We're starting to see litigation in the employer context, the employer, self-insured employer context, where decisions made about spending on particular technologies that is meant to benefit the company and its employees may miss the mark, may not meet their KPIs. And Creative Plaintiffs Council is starting to think through whether those decisions and those investments that had negative outcomes for them in whichever way would trigger a suit for breach of fiduciary duty to the board of a particular company. So founders, this is one you want to keep your eye on. Okay, and the last, because I want to make sure we have time for questions, the last is governance. And I'll just tell you that the reason why I talk about governance here is, and it's a little bit different from, the parallel is HIPAA, right? When HIPAA came out, we thought, okay, what are all the ways that HIPAA can get us in trouble, right? What are all the ways we need to mitigate risk around? And one of those ways is to set up an organization that by nature is built to comply with privacy and security standards. That is the same thing that's happening now. But we are also, it's sort of converging with a moment where the buyers of this technology are changing their governance structures. So what we have been advising clients is, you are going to be clients who are digital health developers, you're going to be walking into sales conversations with an organization who is rapidly deploying an AI governance structure because there is, fear of what the impact could be for patients, for members of health plans, et cetera. So they're walking into a healthcare organization that has a mature governance structure, who is looking for a company on the other side that likewise has a mature governance structure. So you want to be able to walk into those meetings and say, hey, we've defined our ethical guidelines, we invest in continuous education, we have built this alongside clinicians, or if it's not a patient-facing thing, we've built this alongside experts in bias. We've got it goes all the way up to our leadership. We've identified the risks, we've cleaned our data, we constantly test and validate the solution, we have feedback mechanisms. These are all things you want to be able to come into a sales conversation saying, and hopefully truthfully saying. So I would be looking into your organization, whether you're a buyer or a seller. Honestly, these are the right principles, but looking into whether you need to retrofit an existing governance structure or rebuild or build a new governance structure to hit the kinds of principles and rights that we touched on earlier in the presentation. And one big takeaway is just make sure while you're building it, you've got the right stakeholders at the table. If you're concerned about patient safety, a clinician should be there every step of the way. Testing, human in the loop shouldn't be. I think somebody at HIMSS, I was reading an article this morning, said it's sort of a token, right? There's no teeth in it, and companies are just saying, yeah, we have a human in the loop. That should be real, right? That should be a clinician who is testing and validating the output of your algorithm and saying, hey, based on what I know, my profession, and how I would deal with patients, this sounds right, or this doesn't sound right, or what's your data? What is this based on? Does it meet the, is it the right data for the use case? Is it the right data for the people that we're trying to help, right? You should have someone thinking through all those things in your governance structure. All right, and then let's go to our sort of 8 key questions. And we might want to go through this, relatively quickly, Reema, but we have taken all of those key principles that we talked to you about, and we've looked at where they overlap, and we've built our own 8 key questions, right? So this is a harmonized framework based on what we believe the top quality and most important federal frameworks are, sort of broken down for you in what we hope is a really usable resource. So let me hand it over to Reema.
Yeah, thanks, Rebecca. So what we've created is an acronym that we hope will resonate with you. It means, it says sharp enough. So what our goal was throughout this webinar was to help you become sharp enough to understand the risks involved, the frameworks, the principles, et cetera, that are distilled into these 8 key points. So we are running out of time, so I'll quickly go through what these reflect. The first is to think about security of the data that you are using and inputting into the tool, human oversight, making sure that you have a protocol for the providers for clinical decision-making, tools, accountability, making sure you have a team in place who's designated as the responsible person to make decisions for the AI tool, reliability and accuracy, being able to confidently explain how your AI tool was developed and trained, patient safety. We've talked about this pretty frequently throughout this presentation, just making sure that the recommendations are clinically valid and safe. Effectiveness, making sure that you rigorously tested the AI tool to ensure it delivers on the promises you've made to users. Notice and transparency, ensuring you have a process in place to inform patients, providers, and other decision makers about the tools and how they're being used. Fairness and bias is the last one. So ensuring that if there were potential biases in place, that you've addressed those and are making sure you're preventing that in the future.
All right, so crystal ball time. What's coming next, or at least what we think is where the industry is trending from a policy perspective. The first is regulations. There are a lot of frameworks emerging from both regulators and the industry at large. We think the government is most likely to follow FABES and the principles laid out by HHS through the HTI 1 final rule, supplemented by the NIST RMF framework, which they're publishing a generative AI companion. So we think that between NIST and FABES, that's a great place to start as the basis for establishing your pre and post market enforcement structure. One key question that kind of remains is whether the government will try to get specific in regulation, take action such as nominating a certifying body, or whether we'll continue to stick to broad principles and play within our existing regulatory framework and structure that we have in place today. This remains to be seen. Kind of the fights in Washington, if you will, have already started, and those are far from over. We're just at the beginning from that perspective. So one thing to keep in mind is you should position yourself for success by getting started on these AI programs and governance structures that are in alignment with, our sharp enough principles, the FABES principles, and others posted, by industry at large. And to that point, understanding the core principles and building a system in alignment with them is going to, ultimately give you an advantage in minimizing your risk. And this doesn't just apply to those that are using AI tech, right? It applies to vendors and what their customers should expect, and especially those with a mature AI risk management system in place. That's going to be a key differentiator if you can demonstrate that you have a governance structure that is in alignment with some of these core principles. If there's one thing to remember, though, it's this technology is evolving very quickly, and it's entering our healthcare system probably quicker than it is evolving. So there's key players trying to stay at the leading edge of this. And, we're already seeing from a governance perspective, chief AI officers that are proliferating. And, we think that they'll be in place to mitigate the broad impact and risk that's introduced by these technologies. And then lastly, we still need to see how some of these cases come out. You have the OpenAI New York Times case, you have the payers, and how they're using administrative AI. So there's a lot that's, stay tuned to see what's coming next.
Yeah, and just a little like inside baseball on all these frameworks. I mean, eventually we will get to something that's not super painful. Well, I mean, I guess it depends on who you are. What do you think is painful? But eventually we'll get to something that's more defined. Whether everybody likes that definition or not remains to be seen. What's happening right now is the federal government has said, here are the things that we generally care about. Private industry is saying, please, you don't know anything about this technology. Please, please, please don't specifically regulate it. You'll get it wrong. And as soon as it gets through the painstaking process of regulation development, which I did in my early 20s, painstaking process of regulatory development, the technology will have gone to a different place and those won't apply anymore and it'll be very painful. Any of you who have followed the interoperability process know what it's like for the government to try to regulate an entire industry through collaboration, right? So I believe what's happening right now is all these industry groups, Chai and Train, and there's a number of other ones emerging. They are trying to say, look at us, look at how responsible we are. We are coming up with principles that we're going to voluntarily agree to abide by. So you government, you don't need to worry about it. We'll keep you in the loop, right? Well, you'll be right there with us developing these self-regulatory schemes. So we'll see how that works out, right? We've got an administration change coming, possibly at the end of the year. And who knows what the next 4 years are going to bring. So we will be certainly paying attention. And again, we will be updating you as things progress. So I want to make sure we have time for questions. Reema, did you have anything to add?
No, that's
Okay.
it.
Okay, great. Okay, great. So we have a couple of questions already in the Q&A, and I'll invite Reema and Sam to jump in as well. The first one's a little bit of a doozy and has a couple of different parts. So I'm gonna tackle it, but I want you guys to jump in. So the question is, for companies developing AI tools for patients to learn about potential medications for their symptoms. So this is a direct-to-consumer AI-powered digital health solution. How can they protect themselves from generative AI hallucinations? How can patients, I guess, is the question. Or maybe how does the company protect themselves from generative AI hallucinations? And do they need to? This may be a good time, Sam, to talk very briefly about how the FDA looks at direct-to-consumer AI-powered digital health solutions.
Yeah, that's right. And that kind of parlays into another question in the chat about FDA. So from an FDA perspective, you have a general framework that is going to regulate products and services on a function by function basis. So it's going to look at each function that the tool is providing and assess them in a vacuum, right? And then, as discussed earlier, and just to provide the cliff notes here, you're going to have two pathways. One is clinical decision support. The other one is non-devices or devices that are subject to enforcement discretion. The FDA is going to look and see,
or full regulation, right?
Yeah, or full.
Or you got to go through the whole 510(k) process and the whole deal.
Yeah, that's right. And as far as mitigating risk, some of the factors that we're seeing now are, to what degree is the clinician involved? What kind of language is produced by the LLM? Is it just informative, or is it actually getting into diagnosis territory? And importantly, whether or not algorithms can actually demonstrate, or what I'm calling now, whether they can show their work, right? When they arrive at an output, can they explain how they got there, whether it's through references or knowledge maps, or some of the emerging answers to those questions are starting to unfold now. But
yeah, so I think the conclusion is it will be the company's responsibility to make sure that anything that's patient facing, that is giving medical information to patients, is accurate, reliable, all of the principles that we talked about. Do they need to help protect patients? I'm gonna probably say yes. That's the way that you get around going through a full, well, that's how you would get through FDA, right? You have to prove that your solution is not giving faulty information. Yes, it is clear that people are using GPT-4 to Google their symptoms. But if your tool is meant to tell people, so GPT-4 is not built for that. at least not yet. Other companies are using it to do that. But if your tool is meant to give people medical information, you're going to have to look into how the FDA will look at your solution to see what your responsibilities are. Technically, I know Anantha Bangalore is on the phone or on the Zoom, and he's been very, very helpful, sort of explaining some of the technical pieces of this to me. But I know that there is retrieval augmented generation, or RAG, which is one practice that companies are using. A lot of companies are using sort of the human in the loop to analyze the output from a lot of these algorithms, and then to use that, and then the company uses that feedback to tweak the parameters. Making sure that the underlying data is accurate, complete, correct, also very, very important. So hopefully that gives you a little bit of information. Kara Tenenbaum asked, can you talk a little bit about labeling as a potential cure for bias? Did we bring that up today? Did somebody talk about labeling?
We did not, no.
Not. So maybe Kara, if you can add a little bit more to that, we'll answer that. Nora, on the slide regarding contractual and the point on prohibited terms and limitations. Sam, do you want to take this one? Share a little bit more about where the line is drawn between health use cases and general lifestyle and well-being support?
Yeah, I can certainly kick that one off. If we're referring to, how the likes of OpenAI and other, foundational models are putting in their terms what the limitations are, then from that perspective, usually the line is drawn between providing, informational kind of references and then moving into diagnosis where there's some degree of clinical judgment being exercised, nursing judgment being exercised. So I think the key there is, are you just summarizing data and pulling out key points, or are you actually, using the program to diagnose patients with medical conditions? And there's certainly a spectrum there, right? That is going to be an individual analysis depending on the use case. But I think the kind of bright line takeaway there is, the closer you get to diagnosis, the further you drift from general lifestyle and well-being support.
Yeah, there is no hard line drawn. To Sam's point, it's a sort of a spectrum. But I will say that we've seen a lot of solutions that can do the company developing the technology wants the solution to do clinical diagnosis and treatment at some point. But right now they are marketing it as informational, right? So some of it is what the actual technology does, and some of it is how do you explain how you're meant to use it. And we talk to clients about that all the time. All right, it's 1 p.m. Let me look at the remaining questions. Excellent webinar. Great. Thank you, Catherine. Good to see you. Good to see your name. Okay, so I'm going to answer the rest of these questions. We can't do it today because I want to be respectful of your time. Reema, would you go to the next slide, please, just to wrap up? We've prepared a desk reference for you for the Sharp Enough framework with a bit more detail. Use it as you begin to develop a more mature AI governance program. This is something we help clients to develop as well, to prepare them for discussions with their customers and their vendors. You're going to receive this in an email after the webinar. And for all the questions we didn't get to, be sure to follow us on LinkedIn. We can answer there, or we'll follow up with you directly. We'll be sharing some of these answers either there or through our monthly newsletter. And we'll be publishing more content to drive AI-driven digital health companies in our blog. Be sure to sign up for our newsletter. Reema, can you put the link in chat there? And we will use your suggestions from, let's see, this final poll. If you have, can you just put the poll up? It's just asking you for detail on what you'd like us to talk about next time. So add your suggestions to this poll to help us craft our next webinar. Thank you for attending. Reach out to us if you need anything, and we'll do our best to answer these questions. Thank you, everyone. Okay. So it's looking like governance and FDA regulation of medical devices. So we'll have to bring in Mr. Shellhouse. Okay, this is great. Thank you so much, Reema. Thank you so much, Sam. I'm thanking everybody in the chat. We'll pull these questions and we'll try and circle back. We can answer these pretty readily. Okay. All right, Reema, I think we can shut it down. Thanks,
Okay.
everyone.
Thank you.
Thank you.